Good morning. Today, the judgment which I am going to discuss with you would help young advocates to concentrate any field exclusively to make your profession busy, and particularly in the carriers, LR, lorry carriers, and then railway carriers, air aeroplane carriers. So many carriers are shifting goods from one place to other place. There you have to read a relevant act to make you to understand this field of law. I share this judgment which deals with railway cargo transportation, and this judgment would definitely help you if you go through the judgment a few pages. AIR 2025 Supreme Court 2881. AIR 2025 Supreme Court 2881. Union of India versus Kamakya Transport Private Limited. The judgment would also help the central government standing councils who generalises standing councils make themselves be more knowledgeable if the judgment is gone through. It's a case where the respondent booked a cargo and subsequently the railway authorities found that the goods declared in the prescribed form is misdeclaration. Therefore, thereafter they have charged demand notice for misdeclaration charges. That was challenged under Section 16 of the Railway Tribunals Act 1987. Railways Act Section 66, 73, 74 should be read. That is the Act 1989. This Railway Tribunal Act 1987, Section 16, where you can file claim application by the order passed by the authority. That was allowed, but High Court also confirmed about stating that according to Section 73 and 74 of the Railways Act, no charges can be levied after delivery of goods. So somewhat intelligent attempt was made, but Supreme Court has, after reading Section 66, states that when under Section 66, the railway can charge for appropriate charges at any time, and there was no bar to charge even after delivery. Therefore, they have said even claim petition do not propose that the demand notice have been for overloading of wagon. Therefore, our view, Section 66 applied to the present cases. So, in this case, the Section 54(1) also state railway administration may impose conditions not inconsistent with the Act or with any general rule made thereunder. After reading out principles, the High Court order has been set aside, tribunals orders have been set aside, and the original authorities order imposing additional charges has been upheld. So all these things you go through. Some other judgments was also discussed. Best wishes.